Morning, everybody. It's Judge Schreinert.
Good morning.
Good morning, Your Honor.
Before we go on the record, Mr. Davies and Ms. Whitbeck, I wanted to let you know we have a media request from our Nevada judges. We previously had a request made to cover the trial, which of course is not set till November. And I had let our Nevada judges know that since we have a settlement conference before then, I wouldn't make a decision, as of course we're hopeful the matter will settle. We got a request last week about covering this status hearing, and unfortunately it didn't make it on my radar as I was out to give you all notice. So of course I'm aware that pursuant to Nevada Supreme Court Rule 230, Mr. Falcone of our Nevada judges did give request, but the court did not give counsel notice. So certainly you can let me know your thoughts. The other piece is just to let the counsel and parties know our Nevada judges is a site that just essentially opens the courts to members of the public if they so wish, looks at judges' appeals, ratings, etc. For the domestic type cases such as this, any names of parties and children's names would be redacted. So it would not be known. But that is, well, I'm giving you notice at this point that there's a request for the trial, but certainly extremely short notice for a status hearing. And I'm doing this before we go on the record, just so that I can let Mr. Falcone know if he's going to be able to cover it or not, as they like to cover the whole hearing if we have it. So thoughts from counsel?
No objection. It's a public hearing.
Well, exactly. It's the piece is the recording of it. Although, as I've seen them do with other hearings, they do redact as I said, the names. Mr. Davies, thoughts?
Well, I'm not. I think it's weird to consider it a public hearing because every time I go to family court, the doors are shut and so the parties involved.
Well, Mr. Davies, let me I'm sorry to interrupt you, but I did do a bit of research just to confirm this weekend. A custody matter does not have an ability to be sealed. Divorce cases do, and paternity cases are sealed by law. So it is a public hearing. And so actually, I know Mr. Falcone does not have to redact names of children and parties, but they understand the sensitive nature. So, Mr. Davies, I'm sorry, I interrupted you. Go ahead.
No, I appreciate the correction about that. I think for this purposes, I think it's going to be somewhat perfunctory. I know certainly too vital personal information is going to be out. So I don't think we have a trial might be a little more sensitive issue we might object to, but I think for right now I think we're all just putting a finger on the pulse of where we're at with this case. So regarding that, I don't have a huge problem with that though. So.
Okay, and I'll let you all know about the request for trial. If we don't settle the case in October, we can deal with that then. Okay.
Thank you.
And Ms. Whitbeck, you're good. Okay. All right. So then or I think it might be Ms. Falcone, at this point, you are authorized to cover this hearing, as long as the rules I'm laying out is that the name of the child and the names of the parties would not be released. Okay.
Okay. Thank you.
Thank you. Oh, it's Ms. Falcone. Okay, wonderful. All right. So we will go ahead and go on the record. This is FV 20 versus. Let the record reflect we are having this hearing remotely because the courthouse is physically closed, but we're able to proceed as we're all appearing by video. We can see and hear each other. I'm in Washoe County, the site of today's hearing, and I'll ask for appearances, please, and let me know where you're appearing from. Go ahead, Ms. Whitbeck. Oh, you're muted, Ms. Whitbeck.
Of course. Jill Whitbeck through Washoe Legal Services, appearing in Washoe County, and Ms. is here with me. Just there we go.
Thank you. Mr. Davies.
Thank you, Your Honor. Richard Davies here on behalf of Mr. He's president in my office in Washoe County.
Wonderful. Thank you. And Ms. if you can raise your right hands to be sworn, please.
Do you and each of you solemnly swear or affirm that the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Joe?
I do.
All right, thank you so much. All right, everyone, we set this as a status hearing to check in on a few items so that things can keep moving along in your matter. My list says that we are going to check on how visitation is proceeding. And also if documentation has been provided pursuant to the order after hearing regarding any substance abuse evaluations, mental health evaluations. There's a long list. We all have it. It's in the order after hearing. And then also to check in on any testing done by Mr. So I'll just hear from each council. Ms. Whitbeck, I'll start with you. Thank you.
Unfortunately, Your Honor, there's been absolutely no progress. Mr. has not exercised any visitation. He went completely off the radar for more than 2 months. He checked back in through our family wizard on Mother's Day, saying that he would be back in town at the end of the month. When he got back into town, he was arrested. He had at least 2 warrants out. He still has charges pending. The conviction that led to protection order in the coercion and drug possession case was one of his.
Sorry, I muted you, Mr. Davies, because I can hear your client. Okay, go ahead, Ms. Whitbeck.
So the coercion charge, those were the criminal events, including drug possession, that led to the protection order and then ultimately this case. Mr. was failure to appear, failure to meet the conditions of specialty court in that case. That was one of the reasons for his arrest, but there were at least one, we believe 2 others. He still has outstanding charges on at least 2 criminal matters, including battery against Ms. As to the documentation, absolutely nothing has been received. There have been no documents produced whatsoever from Mr. Davies' office since we were in court on March 23rd.
Okay, thank you, Ms. Whitbeck. Mr. Davies, let me hear from you.
Thank you, Your Honor. Mr. and I are getting reacquainted. I haven't seen him for a long time. He's just arrived in my office. He was in Orange County, as reflected from the last hearing. He did enter and complete a 30-day inpatient dual diagnosis drug mental health facility. I don't have documentation of that. I just explained to him that he's going to need that documentation to me. He's been checking in with DAS and pretrial services. He was under the impression that his testing was being turned over by them to the court. I told him I did not think they were going to be doing that, and I didn't see anything filed on eFlex to reflect that. So that's true. We don't have anything to submit yet. I believe, in short order, he can start submitting these things that should have been done in the past. He has relocated back to Reno now because his father is sick, and this can be easier for he and I to communicate about what he needs to do with this case. As far as the arrest on the violation, I don't know anything about that, and maybe he can speak to that.
And then any visitation, Mr. Davies?
Yeah, I don't think there has not been any visitation. I think there's been a problem with the communication regarding that, as far as I can tell.
All right. If you wish to say anything, you may, but just remember that if you have pending charges, this is a recorded proceeding, and anything you say here could be used against you in your pending criminal matter. Is there anything you want to add, sir, to what your counsel stated?
No.
Okay. So my last order stated, first of all, that we would have visits, that they would be supervised. Ms. Whitbeck, can I hear from you on that? Any
Yes,
thoughts?
as I said, Mr. disappeared for more than 2 months. He was gone. He didn't communicate. Right before he left, right after the March 23rd, he sent a request for visitation. Ms. directed him to contact For Your Children to determine their availability. They went back and forth. She repeated the same answer, I don't even know, 3-4 times. It's all documented on OFW. It appears he never did that he never reached out to them, never set anything up, and then he completely dropped off the radar. He did not communicate at all for some 60 days, like I said, until Mother's Day. Then she got an OFW, Happy Mother's Day, I'll be back in 2 weeks. That's it. So there's been no visitation requests since shortly after the hearing, where he was directed to 4-year children to determine their availability, and that's it. He's just disappeared again, like he did in the beginning of this case.
And then going forward, our discussion at our last hearing was about using 4-year children, or perhaps using one of their staff if they were willing to also do visits outside the facility, but still write reports. Do you want to comment on that at this point, Ms. Whitbeck?
We're perfectly willing to go forward with the existing order. Our biggest concern is that, Mr. Davies has my respect for doing his job. He has no clue what's really been going on. And I was told he had documents in his file. This court was told Mr. Davies had documents in his file that would be produced. And then whatever came in after that would be forwarded. I don't have what's in Mr. Davies' file, which includes Mr. mental health evaluation, which according to the docket in his criminal case is an extreme high risk mental health evaluation. So we don't know. Now I'm hearing he did a 30-day inpatient rehab. Great. He was gone more than 60 days, completely off the radar, more than 60 days. So 30 days are accounted for, the rest is not. Everything with Mr. is so up in the air that we're exactly where we were when we started this case. And his visitation needs to remain supervised unless and until these pieces get pulled together, if he's going to cooperate to pull these pieces together.
Mr. Davies, I do recall, I'm looking at my notes, that there was discussion that you did have some of the earlier evaluations because your client had previously been doing the test substance abuse counseling. Do you have anything currently?
And I'm going by memory. My file is with my paralegal right now. I do remember we had a conversation about possibly having documents that haven't not turned over yet. In all candor, I feel like Mr. and I are picking up where we left off back in March, basically, with the original last hearing. So we need to get those things to the court and to Ms. Whitbeck so that we can progress in a more substantive visitation schedule. So that's true. So I will get that file, and whatever I don't have, I get that filed through eFlex as soon as possible. And Mr. I noticed that all the testing and everything he's been doing, whatever he's been doing the last 2 months, he needs to show some proof to the court about that, and the proof of the completion of the inpatient program. I think it was probably going to be the most compelling piece to explain where his whereabouts have been and show that he's on the right track. So whatever I do have in my file that's not having provided, I will get that as soon as I get the file over to my office.
Okay. So at the risk of continuing to build costs, I feel compelled to set yet another status hearing, because what I'm afraid is if I don't see you all till settlement in October, then nothing will have happened. And then we're going to have to push out the trial. And frankly, the child needs to have permanence here. We need to understand, I don't intend to push out the trial. We already pushed it out, because we had discussed that you would be entertaining, some help for 6 months. So that's why it was set that far out. So what I'd like to inquire is if we set a status in August, if that will be sufficient time, because I want, first of all, there's a really long list in the last order, right? But specifically, any evaluations that were already done will be extremely important for there to be discovery on. Any testing, any progress. It's great that you've completed a program, but we need to see that. We need to see proof of that. And so what I'll ask Ms. Whitbeck, it won't be lengthy, but since you drafted the last order and you can cut and paste, what I would ask is that you draft this order just stating that there was not compliance, reiterate the visitation order, which will be the same. So that's 2 opportunities. One is visit with your children. I have to mute you again, Mr. Davies.
I've-
That's okay. One would be you can visit with for your children, or if you can both agree on a staff member who would be willing to do visits so they can be out in the community in a safe way and they still write reports, that's still fine. Obviously, there needs to be some reconnecting in a safe manner here for your child. And reiterate the order on providing first what's in Mr. Davies' file, and then second, anything on the list that can be gathered in the next 30 days, which will be turned over, and then we'll have a status in, I would suggest mid-August for half hour. I'll have my clerk look at a date. Okay, Ms. Whitbeck, anything else that would be helpful to move things forward?
No, Your Honor, other than obviously we want the rehab records now, that's a new element of this, not just a certificate of completion, but the actual records from the facility. So Mr. can provide a release through his counsel, and I'll order up those records to avoid a subpoena, although I'll probably have to do both, a subpoena with a release because of the nature of the records. He will need to provide a HIPAA compliant release, however, that also specifically states within it that substance abuse and mental health records are to be released.
Is that something that you have, Ms. Whitbeck, already in your hand, maybe that you could send over to Mr. Davies, or no?
It sure is.
Okay, so I think that would be helpful to Mr. Davies if Ms. Whitbeck sends over the release that has all that detail. Mr. Davies, you could take a look at it. Basically, you need to be an open book here, so I can understand everything you're doing to make things better. And so I'll ask that you cooperate with that, but of course you need to discuss with your counsel. All right, so Ms. Whitbeck, you'll send by the end of this week over the release to Mr. Davies. And then Mr. Davies, you will review that with your client, get that signed. 30 days might be pushing it for getting document, but I'd certainly anything we have now, and Mr. You can go get your file from pretrial and get that to Mr. Davies. He can get that over to Ms. Whitbeck. There's things that can be happening while we're getting any medical and treatment records.
And Your Honor, I'd ask that I get that release back within not more than 7 days, because it will take, if I don't get it until the end of July, I'm not going to have records, particularly if this was a California facility. They just don't work that fast.
Okay, thank you. Did you hear that, Mr. Davies? And would you like
Yes.
to comment?
Nope, we'll work on it.
Okay. All right, so the HIPAA release, Ms. Whitbeck will send to Mr. Davies this week, and Mr. Davies will get it back within 1 week. So Mr. You need to sign it as soon as your counsel approaches you with that. And then we will come back. Let's see, Madam Clerk, when do we have a half hour? Mid-August or so?
August 16th at 3:30, Your Honor.
All right, can everybody check their calendars, please?
Unfortunately, I got sentencing in district court at 3:30. I could do a little earlier if that works for half hour.
Probably not. We'll pick a different day.
We have the 17th at 9 a.m.
I am in Lovelock at 10 o'clock. I apologize.
That's all right. We're all busy.
We have the 18th at 4 p.m.
I think I can do that. I'll work around that. August 18th, 4 p.m.
Does that work for you, Ms. Whitbeck?
Yes.
All right. So counsel, if you want to do any research, it's the Nevada Supreme Court rules, part 4, starts at rule 229. 230 goes through what I need to consider. since you need to start considering the request for the trial. It's obviously, they're not just requesting to be there because this is a public hearing. They are requesting to be able to broadcast with redaction. So that's what you need to consider. Why don't we just put that on our list of things to discuss in August? See if you have any questions. Okay.
That was Supreme Court Rule 230, Your Honor.
Yes, Nevada Supreme Court Rule 230.
Thank you very
And then
much.
there's other rules around that. So I will, at this point, give permission for our Nevada judges to be here at the next status. And then that's where we will discuss the trial. Okay.
Sounds good. Thank you.
Okay. Thank you, Mr. You're back in town. I'm sorry to hear about your father, but we need you to step up so we can get this resolved. Okay.
Yes, ma'am.
Okay. And thank you, sir, for being here. Ms. Thank you for being here. And I'll look forward to seeing what we get turned over and filed in for our next hearing. Thank you.
Thank you, Your Honor.
Thank you, Judge.